Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education commentary, and today will be the day I earn that subscription. For today's story, we're dealing with a U.S. Supreme Court case that deals with how lines are drawn for congressional districts. Every state gets some Congress people, some more than others. Someone has to draw the lines. It's the state legislature that gets to draw the lines. But the question before the U.S. Supreme Court is it only the state legislature that gets to draw the lines, the state legislature acting alone? In other words, does even the governor, the executive branch, or does even the judicial system in sort of state courts, do they have any role at all in reviewing this? So this is an issue in a case called Moore versus Harper, which deals with this question on what's called the independent state legislature theory, that it is the legislature, literally only the legislature, that can draw these lines, and not the executive can't do anything about it, and the judicial branch can't do anything about it, at least on the state level. So we're going to discuss an article that's discussing this case, some of the issues that are at play. Let's get started with this. Due to the 2020 census, the North Carolina legislature was required to redistrict, draw new district lines for both its state legislature and for the federal legislature, the U.S. Congress. So the North Carolina legislature did that, but in February 2020, the North Carolina Supreme Court struck down both legislative plans for redistricting. The North Carolina General Assembly responded by providing new legislative and congressional plans to the state Superior Court. So they updated both the plans for the state legislature and for their representative to the U.S. Congress. The court accepted the state's plans for the state legislature, but rejected the plans for the U.S. representatives because it failed to meet requirements of the North Carolina Supreme Court's previous ruling. The court instead adopted its own plan created by a court-appointed special master to be used for the midterm elections. So the state legislature produced a map. The court said no and sent it back with instructions. The legislature tried again, but they said no. And here's the kicker. The court then put in place its own map. They appointed their own officials to draw their own map and said, well, because you can't do it, legislature will do it. But now the court is the one adopting the legislative map rather than the legislature. So we have a couple different questions. Can the legislature act completely alone? And if not, can the judicial branch provide a remedy of a revised map? So let's read some more. While the permissiveness of the state's plans, of course, have bearing on North Carolina, the larger issues at play could have a result in vast changes to elections in the United States because the defendants in the case, that is, the state legislature, are asking the court to adopt what's called the independent state legislature theory. This theory posits that the election and presidential election clauses in the U.S. Constitution give state legislatures exclusive power to regulate elections without limits from state constitutions, state courts, or independent commission. So the idea here is that there's power given to the state legislature from the federal constitution. So the federal law would be supreme, as it always would be, right? So the idea is that the state legislature, when they're acting in this capacity, when it comes to drawing congressional lines for congressional legislatures to the U.S. Congress, they're doing so not pursuant to state power, strictly speaking. They're doing so pursuant to federal power, power that's given to them by the federal Constitution. And because this is power that's given to them by the federal Constitution, the state courts, therefore, would not have power to overrule what they did. So this is the idea, right? Maybe the federal government, maybe the federal courts could do something, but not the state courts, not the state legislature, or not previous state legislation, more to the point. The state legislature would be able to act completely independently of their state Supreme Court or whatever state law would be in play. That's the idea. As far back as 1916, the U.S. Supreme Court has reasoned the word legislature, as used by the relevant provision of the Constitution, does not refer exclusively to the elected body of representatives who make up the state legislative branch, which kind of makes sense to some degree because the legislature isn't like acting alone ever, right? They're part of the government. So this would be a very weird interpretation. Instead, it refers more broadly to any individual or body that poses some part of the power, which the court is referred to as legislative power, which, to some degree, depending on how you frame such things, doesn't belong merely to the legislature, right? So, because the governor's power to veto, for example, could be viewed as legislative action that exists within the office of the governor. So just because it exists in some other branch or some other entity doesn't mean it's not legislative power. So even when not done so directly, the court has repeatedly repudiated the underlying pinnings of this theory. Yeah, so the idea is that the legislature alone is not the one with legislative power. They might have the dominant legislative power, but there are other elements of legislative power in other institutions. Voting and civil rights advocates have been raising the alarm about the possibility of the Supreme Court adopting the maximalist position because it could have dramatic negative implications for the administration of elections. An amicus brief submitted to the court by election administrators warns about the possibility of accepting this theory, which would open up numerous state laws, constitutional provisions, administrative rules, and ballot measures to federal litigation, severely limiting the ability of state executive officials like the governor, secretary of state, or local administrators to issue orders, dealing with national disasters, and creating chaos. Yeah, the Supreme Court doesn't seem like they're going to adopt this maximalist position. This does not seem like the direction the Supreme Court is going to go. The degree to which they'll adopt it at all is still a little bit in the cards. We'll probably cover this as Supreme Court will react at some point, but they're probably not going to adopt the maximalist position. According to advocates who oppose the idea, the key reason the independent state legislature theory poses a major threat to free and fair election is that it gives state legislatures, which herself are potentially gerrymandered, total control over election laws. The only oversight to their actions would be federal court, but with the invalidation of state constitutional provisions, federal courts would only be able to use federal law to invalidate, which would be true if this is a federal power. Only having federal laws as a tool to limit state legislatures is a problem because the most powerful of election laws has arguably been constrained in recent years. And so federal courts might not have the tools necessary to deal with this. And so it might give state legislatures the power to radically gerrymander state districts. Another major reason to worry about the court adopting the independent state legislature theory, according to people who oppose it, is that doing so would result in bifurcated bodies of policy, one for federal elections and another for state and local elections, by nullifying hundreds of law, but only for the purposes of federal elections. So this would create a new source of law for federal elections emerging out of the federal constitution. Chaos and confusion could potentially be rampant. All these concerns, of course, are on top of precedent which suggests that this interpretation is incorrect. So I don't think the court is likely to go for this theory. They're not likely to go for this independent theory. How much they think there is power from the state legislature acting alone is a little bit unclear. I'd be a little bit amazed what they're going to do here, but I wouldn't be surprised if they reject it out of hand. I wouldn't be surprised if they reject it out of hand and be like, no, it's up to the state legislatures to do this, but obviously that can be impacted by the state legislative authority, which includes a state constitution, which itself is an act of legislation. A state constitution is an act of legislation. So the state constitution is legislative authority. So that would be the idea. So I think it's unlikely to be adopted in full, but let's wrap this up. So that brings us to the end of the discussion about the independent state legislature theory that Moore versus Harper has brought to light. A case that I don't think the U.S. Supreme Court is going to adopt. It's inconsistent with the understanding of precedent and really, to my mind, inconsistent with the language. You have to read the language in a very, very particular way, which I really don't think is what the language says, and I don't think what they had in mind.